13 notable authors, including Sarah Silverman and Tenoshi Coates, sued Meta for training its large language model, Llama, using pirated copies of their books. But in a sweeping June 2025 ruling, the Northern District of California handed Meta a major victory, finding that the authors had failed to make a viable case that Meta's conduct violated the copyright law. What does this mean for generative AI, content creators, and the future of copyright? I'm Scott Hervey, a partner at Weintraub Tobin, and today I'm joined by our partner, Matt Sugarman. We are going to talk about the Kadrey versus Meta ruling and what it means for the future of copyright and AI development on today's installment of The Briefing. Matt, welcome to The Briefing. It's good to have you. First time briefing participant, so it's always great to have new voices.
Thank you, Scott.
So, all right, let's start with a little background on the case. So, this case began in 2023 when 13 prominent authors filed suit against Meta. They claimed that Meta unlawfully trained its Llama large language model, so Llama 1, Llama 2, and Llama 3, on copyrighted books that were downloaded from shadow libraries like LibGen and Anna's Archive.
These shadow libraries host unauthorized copies of books, and Meta apparently obtained hundreds of the plaintiff's works from these sites. What's more, internal Meta discussions showed the company knew that the books were high-quality training data, long but consistent, well-written, and valuable for LLM memory functions.
Despite this, Meta abandoned efforts to license the books and opted instead to use the pirated versions. The plaintiffs argued that Meta's actions violated copyright law in multiple ways, primarily through unauthorized reproduction and also possibly through distribution via torrenting.
The core of the court's ruling centered on the doctrine of fair use, and Judge Vince Chabira went factor by factor through the standard four-part test. Let's walk through those, Scott.
Sure, that sounds good. So we all know the first factor, the purpose and character of the use. The court found that this weighed in Meta's favor. The court found that Meta's use was highly transformative. Llama was not designed to substitute or to be a substitute for the plaintiff's books. It was trained to be a tool capable of generating diverse new content across different styles, subject matters, and tasks.
The court acknowledged that Llama could not meaningfully reproduce the author's books. Even when adversarially prompted, it could only regurgitate up to 50 words. That's far less than what courts have tolerated in past fair use cases.
Right. On the second factor, the nature of the copyrighted work, this weighed in favor of the plaintiffs, as it usually does when we're dealing with something like a book or another type of creative work. This is because books are creative, expressive works. But the court noted that this factor rarely carries much weight, especially when the works have already been published.
That's correct, Scott. And the third factor is the amount and substantiality of the portion used. Surprisingly favored Meta. Yes, the entire books were copied, but for the purpose of training an LLM, that was considered reasonably necessary given how these models all work.
And that's when we come to the most important factor, the effect on the potential market for the copyrighted work, so the books. This is where the plaintiffs failed. So the plaintiffs argued two things. One, that Llama could output snippets of their books, and two, that the use of the books as training material for the LLM harmed their potential for the licensing market for AI training. But the court rejected both of those arguments.
And Scott, on the snippets, there was simply no evidence of substantial reproduction. And on the licensing market, the court made a critical point. You can't claim a copyright market for licensing when the underlying use is fair. Otherwise, every fair use would become infringing.
Right, that is a good point. And the judge did, however, flag a third potential harm that might be viable in future cases. If a model floods the market with AI-generated works similar enough to compete with the originals, but he emphasized that these plaintiffs in this case did not develop that argument or support it with any evidence.
Right, and now here's where it gets interesting. Just days before this ruling, in Bartz versus Anthropic, another judge in Northern District of California Judge William Alsup issued a more AI-friendly fair use ruling.
Right. We covered that case last week. So, in that case, Judge Alsop focused heavily on the transformative nature of generative AI. The judge downplayed market harm by comparing the AI use to teachers using books to educate students who then create their own works.
But Scott, the judge pushed back hard on that analogy. He wrote that using books to train AI, which can generate thousands of works instantly, is not like teaching children to write. The potential for competitive harm is so much greater.
Right, yeah. The judge in this case really didn't mince words for his disagreement with Judge Alsop. He called that logic inapt and said that it is not a basis for blowing off the most important factor in the fair use analysis. While both courts found in favor of the AI companies, the judge here was more cautious. He made clear that while the plaintiffs in Kadrey failed on the facts, future plaintiffs, armed with better market harm arguments, could succeed.
So, Scott, what does this mean for the industry? On the AI side, it's a clear win, at least in the short term, and these limited facts. Meta avoids liability here, and the ruling affirms that courts may view large scale model training as transformative.
Right. But there's no blanket immunity. The judge in this case explicitly said that this ruling applies only to these plaintiffs and their flawed arguments. In fact, he said the following. This ruling does not stand for the proposition that Meta's use of copyrighted materials to train its language models is lawful. It stands only for the proposition that these plaintiffs made the wrong arguments and failed to develop a record in support of the right one.
That's right. And for the content industry, this means the door to copyright enforcement is still open. Authors, publishers, and other rights holders just need to come in with better evidence, especially regarding market substitution.
All right, so before we wrap up, Matt, let's talk about a key part of this ruling that may shape future litigation. While the judge ultimately ruled in Meta's favor, he pointed to a third kind of harm that could support a copyright claim in future cases, something the plaintiffs in Kadrey failed to develop.
That's right, Scott. The judge flagged the possibility that if a generative AI model is capable of flooding the market with works that are similar enough to the originals, think in tone, structure, style, or subject matter, even if they're not exact copies, that could be a real form of market harm.
So let's, like we did in law school, let's consider a hypothetical. And I think this works for you given your, client list is mostly authors and a lot of sci-fi authors. So let's imagine one of your sci-fi authors, say maybe a mid-list writer who has a loyal readership and a steady digital sales. So let's assume that a tech company trains its AI on thousands of sci-fi novels, including your clients, and launches a tool that lets users generate new sci-fi stories in the style of your client or any of her peers.
Well, Scott, if the AI starts producing content that's functionally substituting for my client's work, so much so that the readers skip buying my client's latest book and just prompt the AI for something similar, that's a real competitive threat. That's market substitution.
And that's where the evidence matters. Unlike the Kadri plaintiffs, your client could generate AI outputs that closely match her book's tone, pacing, maybe themes. She could run reader surveys showing that people are using the AI instead of purchasing new books. And your client could point to declining sales timed with the AI's release. Maybe even show that the AI's output rankings in the same digital storefront as hers and competes with her titles.
Exactly, Scott. And she could call on expert witnesses, economists or publishing insiders, to name a few, to show that AI generated books are displacing traditionally authored works in the same genre that she writes in. If that evidence is solid, it's a strong fourth factor argument against fair use.
Right. And if your client coordinates with other similar sci-fi authors, similarly affected by this AI tool, they could argue systematic erosion of genre markets by AI platforms and potentially file a class action lawsuit, bolstering the evidentiary record. So it's not clear whether they would be able to be successful in establishing a basis for a class action. However, the judge in the Kadrey case definitely left this one open. So the key takeaway from Judge Shirobara's ruling, I hope I pronounced that judge's name right, is this. Courts aren't ruling out copyright harm from AI training altogether. They're saying that plaintiffs need to come up with the right theory and, more importantly, the right proof. The Kadri plaintiffs didn't, but future plaintiffs might.
Correct. And if they do, we could see the first real limitations placed on how generative AI models are trained, especially with regards to how closely their outputs resemble existing human authored works like my clients.
It's a roadmap. The door's open, just not for plaintiffs who show up empty handed. We may see more strategic litigation, or we may see a push for new legislation, collective licensing regimes, or opt out registries. Either way, the pressure for compensation from AI developers is not going to go away.
Right. And I'd expect that these cases will head towards appellate court soon. The Ninth Circuit and eventually the Supreme Court will likely be asked to draw clearer lines.
Yeah, I agree. So, okay, we've looked at what went wrong for the plaintiffs in Kadri and what could go right in future cases. But now let's flip the lens. Let's talk about what AI companies should be doing if they want to avoid winding up in court and on the wrong side of a copyright verdict.
That's the $1 million or more likely the $1 billion question, Scott. Even though Meta won this round, the judge made it crystal clear that this isn't a blank check. Future plaintiffs with stronger arguments, especially around the market substitution issue, would likely succeed.
Right. The fair use defense only goes so far. So let's talk about what an AI company should do if it wants to train its models on texts, articles, or even video content like YouTube clips. So, all right, let's start with the obvious one, get permission.
Absolutely, Scott. Step one is to license the content, whether it's books, journalism, academic texts, or video. If you can strike a deal, you should do it. Negotiate directly with rights holders like my clients, or look for collective licensing solutions with larger groups. This is the cleanest way to avoid legal and consumer blowback.
And it's not just licensing. Step two, track everything. You need to know exactly where your training data is coming from. Was it scraped from public domain sources? Was it purchased from a vendor? Or was it pulled from shadow libraries? Because in Cadre, that last one, sourcing from pirated books or shadow libraries, that became a major red flag.
Exactly. And if you're going to train on copyrighted material without permission, your best bet is to minimize the exposure. Not that I'm saying you should do that. Don't just vacuum in full novels, song lyrics, and screenplays. Be selective. Target factual or functional works whenever possible, and use snippets and not the full work.
And make sure that your model is doing something transformative. That is the key. If you're just trying to replicate an author style or generate content that replaces human made books or create a central library for some later unspecified use, that is very dangerous territory. But if your model is built to summarize reports, help with code, or support education or productivity tools, you've got a much stronger fair use case.
Exactly, Scott. And another move could be to provide opt-out mechanisms. Give creators the ability to say, hey, don't use my content to train your models. It won't automatically shield you from liability, but it shows good faith, which will be a factor that the courts may consider.
Right, that's a good point, Matt. And also, it's not just about what the model does, it's about how you talk about it. If your product is marketed as a way to, quote, write your next romance novel in the style of Nora Roberts, you're inviting a lawsuit. If your product is marketed as a general productivity tool, the framing can help your legal position.
Right, Scott. And one last tip from me, prepare now for litigation. Don't wait till later. Document your mitigation techniques, like efforts to prevent monetization or regurgitation of training data, retain experts, do initial market impact studies, build the fair use defense before the subpoena arrives.
Right. Because here's the bottom line. After Kadri, the courts are signaling, show us the harm, but they're also saying, don't abuse that breathing room. A careful, transparent, and legally informed data strategy just isn't smart. It's going to be survival for AI companies. All right, so to sum it up, Kadrey versus Meta is a cautionary win for AI companies. Meta dodged liability, but only because the plaintiffs failed to prove the right harm. Courts are going to scrutinize AI training, and market effects are going to be front and center.
Exactly. And content creators should take note. Fair use is not dead, but it's evolving and it's evolving fast. What you argue and what you can prove will make all the difference in the end.
Matt, thanks for joining me today. Always great to have your insights. And thank you to our listeners for joining us on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share it with your network. We'd also love to hear from you. Leave a comment or a review and let us know what topics you'd like us to cover in future episodes. I'm Scott Hervey. See you next time on the briefing.